meeting will now come to order. Will the clerk please call the roll?
Mayor Carlin.
Here.
Vice Mayor Binsbacher.
Here.
Councilmember Patina.
Here.
Councilmember Edwards.
Here.
Councilmember Finn.
Here.
Councilmember Hunt.
Here.
Councilmember Leone.
Here.
Council Liaison Bowden.
Here.
Council Liaison Camacho.
Good evening and welcome to the Peoria City Council special meeting of March 1st, 2016. We have one item on the study session agenda this evening, and it is Sign Code Modernization Project. Mr. Swenson.
Let me give it a little bit of context. Sign code modernization could be a lot of things, right? And this, of course, flows from some court action last year that the council is well aware of, where there was a legal precedent established that changes some of the legal framework by which cities regulate signage all across the country. And so what we have been doing is working through a process to bring forward the changes necessary to our sign code so that we can meet the standards established in this new legal precedent. So there aren't items before you tonight requiring your action, but this is moving to the regulatory process, and we wanted to make sure that you were all well aware of the changes that were going to be necessary, because eventually, of course, all of the recommendations will come to you for action at the end of the process going through the commission. So with that, I'll turn it over to our Planning and Community Development Director, Chris Hawkes, and he'll be supported by our City Attorney, Steve Kemp.
Great. Thank you, Carl. Good evening, Mayor and Council. Purpose of this study session is to introduce a major project that we're unfolding this year, which we're calling as Carl mentioned, the Sign Code Modernization Project. But this is a major restructuring of our sign code. As he indicated, the impetus is a Supreme Court decision that came out last summer that Steve will provide some remarks on in a minute, called the Reed versus Town of Gilbert decision. This was a case that started with challenging set of facts, but resulted in a landmark shift in how we approach sign regulation. So what that decision has done is it's placed Peoria in the same position as cities across the country, and that we are in a position that we have to respond to the new legal landscape that's been created as a result of that Supreme Court decision. So, in the world of zoning, oftentimes we see legislative mandates that come about or Supreme Court decisions, and we have to be nimble and flexible to respond to those changes. However, we're looking at this as an opportunity, as I'll indicate in a minute. Our sign code has been in place largely since 1989 in its current form. So this really provides us an opportunity not only to meet the legal mandates that are required, but also to update it and make it a code that's a lot more relevant for today's conditions. I wanted to provide a few remarks about, what is the sign code and why do we have a sign code? The sign ordinance is a portion of the zoning ordinance, and in that sign code, what it does.
This is obviously not Peoria. Here,
this is not Peoria, but it's regulations where we regulate all public and private signs within the city, and there are stated exceptions. We don't regulate traffic control signs. There's also provisions for types of government speech. But most jurisdictions throughout the country have a sign code. There are a variety of reasons that we might limit or control signage. Probably chief among them is promoting public safety. We want to ensure that signs are constructed in a manner that do not cause harm to the citizens. They won't fall down. They won't obstruct view corridors. They won't injure the public or unduly distract motorists. Also to keep the system functional, which is to move traffic. There's also purposes looking at the effectiveness of sign and to promoting an attractive environment. So yeah, the photo you see obviously is an extreme example that's nowhere near Peoria, but you can see the forest of signage out there. And so I think what we try to do with the sign code is find the appropriate balance that provides businesses with appropriate signage that identify their businesses without creating a distraction, without negatively harming the community aesthetic. And I think if you look at that photo, not only does all the signs kind of get lost in the forest, but I don't really think you see any. The signs aren't really accomplishing what their stated objectives are to do. And also, we think there's a tie for the sign code with our community image and also economic development. I mean, a nice sign code, a nice built environment also is an attractor and an inducer to tourism opportunities and business attraction efforts. So it's all part of that community aesthetic. So very important that we have a well-balanced sign code. All right, here we go. As I indicated, this is an opportunity for us to modernize our sign code. We've made amendments to the sign code since its place since 1989, but a lot of things have happened. I think you're looking at some of the photos. Hairstyles have changed, right? A lot of things have happened. Good thing that that's happened. But there's some outdated terminology within our sign code that we have to deal with. Back in the late 80s when the current sign code was formulated, we were a much different city. We were a city of 50,000. We're about a third of the size of what we are today. Arguably, the sign code was much more highway commercial oriented. The major thoroughfares throughout Peoria were Bell Road, Grand Avenue. So a much different sign code, and really a sign code without the standards in place to, particularly to recognize some of the, distinct districts that we're trying to enable today, like the P83 or what's on the horizon, the Auto Mall district. And so, with the sign code modernization, not only can we update some of the terminology, make it more user-friendly, reduce the number of pages, provide graphics, but it just gives us the ability to, communicate our message on our expectations for the sign code. All right, let me just click through these. Oops. All right. Current sign code is about 48 pages long. That's pretty large for a sign code. We've seen sign codes all across the country. That's a long sign code. It's text heavy, it lacks graphics, 33 different sign types. So our objective will be to try to find a way to provide it in a much more usable format so that we can communicate our objectives to the public and to businesses that use these signs, use tables, pictures, graphics, make it more graphically oriented. But probably the most important reason would be to maintain the legal enforceability of the regulations, make sure that they were in compliance with the Reed decision. So what I'm going to do is stop right there for a second. I'm going to turn it over to Steve. Steve's going to talk about the legal landscape, and then we'll come back and talk about our approach to the sign code.
Good evening, Mayor and Council. When the sign code was adopted back in 1989, there had been a U.S. Supreme Court decision in a case called Metro Media versus City and County of San Diego, and basically what it stated was that we would look at a rational basis standard in enacting a sign code. That if a local government had a rational basis, then a sign code should be upheld. And so cities across the country, including Peoria, adopted sign codes. Well, this past year, the U.S. Supreme Court decided the Reed case, and Reed happens to be an Arizona case. I'm very intimately familiar with it because it involved the town of Gilbert. And it actually started out in the U.S. District Court here in Arizona. And basically, it was a small church that argued that Gilbert's sign code regulated the signs based on the content, and that essentially the reasonable basis standard should not be applied, but that because it regulated based on content, that the standard that is applied for First Amendment cases, what we call strict scrutiny, should be the standard applied. Now you're thinking, well, this all sounds like legalese. What does that really mean? Well, the difference is rational basis just means if a legislative body had a basis for doing something, it should be upheld. Strict scrutiny means two things. First, that you have to look and find a compelling governmental interest in the regulation. That a compelling interest is so overwhelming that there's no other solution but to regulate. But that's not enough. Secondly, the regulation has to be the least restrictive means. That if there is a lesser, more restrictive means to accomplish that goal, and the regulation is more restrictive, then you haven't met the strict scrutiny standard. So when this went from the federal district court, and surprisingly, Gilbert actually prevailed in the district court. It went up to the Ninth Circuit initially. Gilbert prevailed again. Back to the district court. Gilbert prevailed again. Went to the Ninth Circuit. Gilbert prevailed again. But then it gets to the U.S. Supreme Court. And I was very familiar with the arguments because as one of the members of the amicus committee for the International Municipal Lawyers Association, we looked at this case extremely closely. In the arguments in front of the Supreme Court, none of the justices had any questions or comments supportive of the town of Gilbert. And that's usually not a good sign when you're in front of the Supreme Court. you normally, particularly with this divided court, you would expect to find some justices that would be supporting your position. That wasn't the case. When the decision came out, again, probably this was the only case last year where all 9 justices agreed on a number of things. And we're talking folks from as broad a perspective as Clarence Thomas and Judge Anito on one end, and Judge Sotomayor and Justice Kagan on the other end. So you are talking about a very broad perspective. All 9 justices, including the late Justice Scalia, found that the Gilbert sign code was a content-based code that, in essence, it should be struck down as unconstitutional. Now, the only problem was, if the court had given us one opinion, it would have made things very easy. However, they gave us 4 opinions. 4 judges joined in one opinion, Justice Alito had a concurring opinion, and then the 4 dissenters had 2 opinions of their own, which from a lawyer's standpoint, I can tell you is entirely too much reading to try to figure out what the court really was saying. But essentially, there were a lot of common thoughts among the court, which were that the Gilbert Code was content-based, that made it unconstitutional, and Justice Alito, I think, really hit the major points, which was that he felt that, yes, you still could regulate signs, but that regulations had to be content neutral. So what do I mean by content neutral? Content neutral means that we are regulating not based on anything on the sign, but other factors. For example, lighting. Certainly a sign that is extremely bright in a residential neighborhood has a lot of issues. It's totally content neutral. It doesn't matter what's on the sign, it's the lighting that is the issue. A size, building materials. If a sign is made out of steel, and this is a neighborhood that perhaps is all brick or all stucco, that could become an issue. Moving parts, or whether it's a small portable temporary sign or whether it's a permanent sign. Now, immediately, one of the interesting things about the Reed case was that normally a Supreme Court case like this, as a lawyer who's practiced in this area, you kind of expect the dust to settle, and everybody just kind of thinks, okay, well, we're going to have some time to deal with this. Within a month after Reed was decided, 4 different circuit courts, and circuit courts are the intermediate federal appellate court, decided 4 different types of cases, and all cited the Reed as the principle that these signs in each case were content-based, and that therefore this was protected First Amendment speech and should be subject to the strict scrutiny analysis. Since this time, 2 other circuit courts, so now we've had 6 out of 11 circuit courts, all adopt the Reed analysis at the intermediate level. And I can tell you, in a 6-month period for that to happen, literally, I cannot recall another U.S. Supreme Court case that has ever had that kind of impact. And so what does that really mean for us? And if you want to go into great detail on Reed, by all means, give me a call and we can sit down and talk about Reed for hours on end, because there's a lot of fascinating things about the facts and the circumstances. Well, what it means for us is that, like many sign codes, the Peoria Code that was written back in 1989 is a content-based code. We regulate signs based on content. We have different standards for certain signs because they're temporary versus permanent. We have signs for home building on the weekends, church signs. We look at regulating signs based on content. We can't do that anymore. That's gone. And we sometimes will regulate based on use, but the use that we are looking at is really tied to the content. We're not really looking at these objective factors that don't require us to look at the sign. In essence, as the slide indicates, you can't read the sign to enforce the code. That's the goal here. is that we're going to be looking at objective factors that have nothing to do with the content of the sign. That is what the content neutral standard requires, and that's what we're going to be doing. Now, I will tell you there's a couple of other cases working their way through the federal court system that likely will come back up to the Supreme Court and may even extend Reed further in areas such as billboards. We are watching those, and we're keeping a very close eye on those, but I don't think we've seen the end of sign issues by any means. So based on this, that has now led us to do the sign code modernization, because obviously we want a legally enforceable sign code, and we don't want a situation where parties are coming in and simply suing the city and saying, we're going to choose not to comply, or we go to federal court and we just simply have a judge strike down the entire code and we have nothing. Because if you have nothing, then go back to that first slide that Mr. Hawker showed you, and that's the result of nothing. So we are moving, our staff is working very closely with the Planning and Community Development staff to work through a process to bring you back a legally enforceable, what I would call Reed-compliant sign code. And with that, I'll go back to Chris.
Okay?
Excuse me, before you move backwards again, can you go back a few slides? Actually, like when you, towards the beginning of the legal portion here, there.
There you
So this yard sign, this good news yard sign, was this entire case predicated on that yard sign?
Yes, it was. This was a little house church that met in a school. And Gilbert had a requirement that you could only have these signs up for 2 hours on Sunday. And that was the only time they could be up. So for whatever reason, Gilbert Code Enforcement went out and the signs were up too long and confiscated them. Now, what one would normally think is the pastor would sit down with Code Enforcement and there would be some kind of understanding and life would go on. Well, this particular church hired a public law entity called the Alliance Defense Fund, which specializes in taking cases up to the federal courts and striking down regulations on religious freedom. And so instead of this being worked out, they sued Gilbert. Gilbert litigated, and again, I would expect normally you would have a case like this, and even if the city prevailed in district court, you would say, listen, this type of litigation is very, very expensive. My guess is by the time the parties are done, both parties spent well into the 6 figures, maybe even into the 7 figures. This is not cheap litigation. And again, the parties would work it out, but that did not happen. So this case, to answer your question, all of this litigation over the course of about 3 years, all resolved around that little sign saying Good News Presbyterian Church.
Wow, that's pretty amazing. It's a very small sign, but obviously it looks very similar to the signs in the picture below it, which were regulated differently, correctly? Is that correct?
And that's correct. And that is one of the wrinkles that we have to deal with in Arizona, is, as you'll recall, a couple years ago, our legislature passed a law that creates an absolute right to place political signs in the public right-of-way. And in fact, there's also an amendment to that bill this year proposing to even extend that right further and create longer times for you to have those signs up. And that statute also precluded cities from adopting different codes. So one of the issues that comes up now is that, well, isn't this really a content-based restriction because cities aren't adopting the political code standards for all of their signs? I would tell you that becomes a real problem because essentially that would mean a good portion of the year, every single sign would be in the public right-of-way. And so it's something that we'll deal with in our code. It does add a little wrinkle to what we're dealing with that we just are going to have to, it's a quirk in Arizona law that the state legislature's given us.
So with an election period of time coming soon, how is that going to be handled? If it's
okay.
against the law?
Well,
Is the exception political signs?
well, the exception will be political science, and you'll be getting from us, working with the clerk's office very soon. And again, we're waiting to see what will happen with that bill. Assuming that bill doesn't pass, you'll be getting some information from us saying the time is now open, and political signs can be in the right-of-way for those folks who are candidates, and subject to certain restrictions. Now, obviously, if you put your sign in front of a traffic control sign, we're going to remove it. And,
But that's our current
and that's our current code. And it will be basically the same standard that occurred in 2014. And if one remembers the last election, there were a lot of political signs up, and that will be the standard that will be applied again. The 2014 sign standard was the basis, was the implementation of that state law. In 2012, that law, I don't believe, was in place, but what you saw in 2014, that is what you're going to see in 2016.
So Reed does not apply.
And Reed isn't going to change that factor. That factor may impact us in some of our regulations on signs, because we have to deal with the fact that the state has kind of opened up this whole door.
All right, thank you.
Any other questions on the legal landscape before we move on to the third item? All right, I wanted to spend just a few minutes and talk about our approach to the sign code. Obviously, this is a big effort in front of us that will be unfolding over the next year. As we approach any sign code update, we're going to have to ask certain questions as we move through it. What types of signs are appropriate in the city, and what parts? How large should a sign be? How many should we allow on a property, looking at a commercial and a residential context? What duration or what time frame should we allow signs for, particularly with temporary signage? And do we require a permit or not? So those are some of the things that we'll have to ask ourselves as we move through it. The objectives, as I mentioned earlier, is to look at the sign regulations that we have, identify the ones that are relevant for today's conditions, and how are they most effective in meeting our stated public purpose in terms of signs. I talked about promoting public safety, creating an attractive environment. So with those parameters in mind, how do we move in that direction? As I mentioned, also creating a clear, concise, legally defensive code and modernizing it, changing up the format, graphics, and different formatting methods. So as we move through it, too, there's also going to be items for consideration that we'll have to ask. Steve talked about the wrinkle, the political campaign signs, and how will that affect other types of particularly temporary signs that we have. How do we address schools? I mean, right now, schools are a separate political subdivision of the state. Is it something we even address in a sign code? Maybe it's not. Maybe it's something that's accepted out since they are a separate entity. How do we address signs in the right-of-way? How do we address special districts? And so let me spend a minute on the special district aspect. There is an effort that will be concurrent with this one, and that is identifying sign standards for the P83 district. We've gone through quite a bit of visioning over the years on the P83 and the energy and the look that we're trying to establish with that district. And so we believe it's a distinct area, and with standards that probably should be distinct from the rest of the city and the sign code. So we're looking at that concurrently as well. We know there's interest from some of the businesses in the area in terms of sign opportunities. So certainly, as we go through this process, we're going to have a parallel process with the P83, and we'll figure out the corrective vehicle, whether it's an overlay, whether it's a district, or whether it's a PAD we do for the entire district. But the intent would be to look at them both at the same time and to have some consistency between some of the definitions and the structure of it.
Thank you, Mayor. Chris, can you, specifically to P83 and potentially with the auto district, so what's the time frame for all of this to come into play? Because as you know, P83 has spent a lot of time and effort. There's new businesses coming in. So are we talking 6 months? Are we talking a year for this? And during that time frame, can we do some kind of an overlay to a PAD that's existing to allow signage for existing or new businesses? Because I'd sure hate to have a business or even like Huntington University that's coming in to have to wait 6 months to a year to be able to put signs up while we're going through this process.
Councilmember Edwards, that's a great question. And at the end, I'll show a slide that identifies the time frame. But the time frame that we're looking for is to bring a final ordinance to council this year to act on. And as I indicated, the work we do with P83 is intended to parallel that effort. However, understanding there's a lot of interest in the PD3 area, there is the opportunity to have, to meet with business owners and perhaps entertain changes to their PADs, to look at, some sign standard changes that occur in advance of the overall update to PD3. Now, we'll want to make sure that it's compliant with READ. We'll want to make sure that it's moving in a manner that's consistent with the rest of our sign code and provides some parity in the district. So there is those opportunities that we can do that, and certainly we're willing to meet with, with individual businesses as we go through this process. So Steve indicated that early on that as we go through the modernization, that we cannot make distinctions on sign standards based on the sign content. We can make sign distinctions on other types of features. We can distinguish sign standards based on location. So that, if you're a location on an arterial or a collector, or whether we're talking about a building-mounted sign or a freestanding sign, we can make distinctions on zoning, so commercial, industrial, residential. We can make distinctions on duration. So what I mean by that is it a temporary sign? Is it a permanent sign? Is it a one-time event, or is it a longer-term event, like a political season, a political campaign? And also based on the features of the sign, lit versus unlit. So we're really going to be looking at not the message, not the content of the sign, but more of the features in a class that characterize that sign. That's how you'll see sign standards, I believe, that are classified. This is just intended to show you, I talked about adding graphics and tables and formats, so this is a potential approach in taking that sign code. Again, the objective is to make it much more usable, to make the code a lot more concise, and not have 48 pages of text that we're dealing with ambiguous terms, but make it a lot more user-friendly, and I think that just helps everybody in terms of the business and public understanding what we're trying to achieve with our sign code and us trying to communicate our standards more effectively. In terms of the time frame, tonight is the first study session where we're just introducing the topic to the council. We're going to be going in front of our planning commission this Thursday and also having a study session with them. We're going to be reaching out to stakeholders, and so we're going to be reaching out to a variety of stakeholders. We've identified the Home Builders Association to talk with, Valley Partnership, sign companies, the Multifamily Housing Association, local businesses throughout Peoria and also in P83. Nonprofits and the general public. So we'll want to get their input and impact in terms of some of the questions I identified earlier that we'll have to look at in revising the sign and coming up with a sign code. We'll look at revising the draft in spring, having a second stakeholder meeting probably in late spring this time, coming back at the end of summer with the Planning Commission. We'll look early this fall to bring back in a study session with the council a draft sign code for your input and your feedback on. And our objective would be to have all of these back for Planning Commission and council action, as we indicate down here, fall, winter of 2016. So the latter part of this year. That's the objective. Okay, and that's all I have on this item. Are there any questions on that?
Council, any questions? Well, it looks like you've got your work cut out for you.
We do.
Okay, well, seeing no further information?
No, that's all we had in terms of presentation. This is the only item we had in the study session.
Okay, thank you. Then we are adjourned until our 7 o'clock regular council meeting.